inquisitorial power. To the contrary, and this is the important portion of this quotation, it is a proper application of state power to ensure that the law is correctly applied. Yeah. That's the rationale. We acknowledge, Justice Mpati, that we have two major hurdles to cross. The first hurdle that we have to cross would be the hurdle that was formulated in the matter S versus Sequi. And that we have to convince the court that the court would be able to consider the questions, although there was not a complete acquittal. We will deal with that. After that, Justice Mpati, we will have to convince the court, this court, that we're dealing with errors of law and not errors of fact. May I refer to that as the Mahmoud hurdle. We have two hurdles to cross, the Sequi hurdle, the Mahmoud hurdle. In terms of the Mahmoud hurdle, we will deal in our submissions, firstly, with the erroneous application of the principles guiding circumstantial evidence, and more particularly in excluding very important circumstantial evidence by the court of quo. With that, we will deal with the erroneous application of the law in dealing with a plethora of defences by the court of quo. Then we will deal with the erroneous application of the principles of dolus eventualis to the facts as found by the court. We will do that. Justice Mpati,
and of course you'll set out what those principles are.
Yes, indeed. Justice Mpati, we want to acknowledge up front that we were not happy with the factual findings made by the court. But because that is so abundantly clear to everyone, we were very cautious in our heads of argument, and will be cautious today, not to attack the factual findings of the court, but to deal with errors in law. So if I may then deal with the Sequi hurdle, we have 4 submissions to make.
But you have to deal with factual findings insofar as it's relevant to the assessment of the legal principle.
Indeed.
Whether those facts as found to be proved were properly dealt with in terms of the necessary legal principle.
Indeed, Justice Leach, and if there was erroneous application of the legal principles as far as circumstantial evidence is concerned, we will be making submissions that certain of the factual findings that the court made, the court never applied. So on the Sequi issue, Justice Leach, we have 4 submissions to make. Firstly, the court of quo did not, as the court did in Sequi, view a competent verdict, a decision on a competent verdict, as the same charge. In Sequi, the court made a finding indicating that a finding on a competent verdict, that a charge is a charge of which different convictions would be possible. What the court of quo did, the court of quo clearly indicated that the accused was acquitted and discharged on a charge of murder, and the court said instead convicted of culpable homicide. So the court of quo correctly, with the utmost respect, dealt with a competent verdict as we understand and as we will make submissions. Section 258 should have been understood. Section 258, we say, just exclude the requirement by the state to list alternative counts. It is a competent verdict can be nothing else but alternative counts in terms of 258, which exclude the requirement from the state to list them. We say that the court of quo did exactly that.
Can I just ask you, would it have been sufficient if the court had simply said, the state has not proved the offense of murder, and stopped there and then carried on, that's not the end of the matter, and went on to consider culpable homicide?
Again, Justice Mpati, that would have had the same effect. I say that if the court would have said the state did not prove, it is, with the utmost respect, the same as you acquitted on the count.
Yeah.
So if the court said that, but the main question, Judge Mpati, would be that how one would view a conviction on a competent verdict. We say respectfully, a conviction on a competent verdict is the same as a conviction on an alternative count. In
He
Sekwe,
was charged with murder and he wasn't found guilty of murder, and that you say is the equivalent of an acquittal.
I say differently, Justice Leach. I say the conviction on culpable homicide is the same as a conviction on an alternative count.
Yeah.
Yeah, that's what he says.
Sekwe says an acquittal is when the accused is set completely free altogether. So what is the situation here in this particular matter?
Justice Mhlantla, I just didn't hear that. I really apologize.
I'm saying that in Sekwe it says an acquittal, the meaning thereof is when the accused is set completely free.
Yes.
In this particular matter, what happened? Because we know that he was charged with murder.
Justice Mhlantla, we argue that on the main count he was completely set free. He was convicted on an alternative count. In Sekwe, Justice Mhlantla, at the end, page 104, I think it's 104, the court said, we specifically leave it open if accused is convicted on an alternative count. In in Harmeyer's matter, in Harmeyer's matter, I apologize, I get things from behind and
That's fine.
I have to apologize. They know much more than I do, so I will have to rely on them. In Harmeyer's matter, the Orange Free State Provincial Division made a finding by acquittal in section 369, that was the predecessor of this particular article, section of the Act as amended, is meant an acquittal on the charge on which the accused was charged and acquitted, and not the conviction on a possible alternative charge wherewith he was also charged or could be convicted.
Mr. Lau, I think if I can quote directly from Sekwe, and Sekwe is important because you know that in Mahmoud, Sekwe was quoted apparently with approval. If you look at 104B, and I'll summarize it in English, it says, by virtue of the above, I'm of the view that where somebody is charged and then convicted on an offence on which he may have been convicted in terms of the provisions of section 26 hoof 26 van die wet, that's competent verdicts. Daar nie gesê kan word dat daar 'n onskuldig bevinding was soos in artikel 322(4) bedoel nie, and that's what my learned colleague is referring to. So it seems to me that based on that dictum, what the court had in mind, what Rabi J.A. is referring there to, is a complete acquittal. And having said that, is there not a shorter route to the problem that you're postulating now, the difficulty that you correctly say the state must surmount? Is the short answer not that Sekwe is no longer good law in view of State versus Basson in the Constitutional Court?
Indeed.
Things have changed drastically
Indeed.
since Sekwe, if you read Basson.
Justice Majid, I 100% agree.
If we find that Basson has in effect done away with Sekwe's reasoning and motivation, is that not the end of the matter as far as this particular question is concerned?
Indeed. We said we'll be making 4 submissions. I've made 2. That's my 4th and main submission, as indicated in our heads of argument. The matter in Basson is so clear, where the court said at page 621, at paragraph 148, there's nothing in this language to suggest that the state may only request the reservation of a question directed at, and that's important, conviction or acquittal of an accused.
And there it was dealing with the situation where these limitations come from, and that's the case of Adams.
Yes. And Justice Mpati, we say, and as we did in our heads of argument, that Sekwe is not good law anymore. I agree, Justice Majid. Basson evaluated the section 319, is the first post-constitutional decision on 319, and correctly interpreted 319, as the court said it should have done, where the court indicated Act 619, one of the consequences of the advent of our constitutional democracy is a requirement that all laws must be construed in the light of the Constitution, which the court did. So we make the submission that even if this court would not find that it was a bad law, then we have a submission on the alternative count and the competent verdict. But our main argument is that since Basson, Sekwe is not applicable anymore. And therefore, we have a right to argue that the court should make a finding on the questions as posed.
Because one can conceivably have glaring miscarriages of justice. For example, there's a full trial with all evidence led, and the judge makes one or other glaring mistake in the course of assessing the evidence or coming to a conclusion on the law. Then the accused, for example, is found guilty of culpable homicide, not of murder. But there's, as I say, a glaring error on conclusion of law. That means that the state cannot appeal because there's not been a complete acquittal.
Indeed.
It really, it's difficult to understand why that should be the case.
We've made the point in our heads, Justice Majid, that would be absurd to even think that. If we get to Mahmoud, it is clear that Mahmoud is also pre-constitutional, because the court went so far in Mahmoud as to saying the state does not have the same rights as an accused person has. The state is a minor partner in this trial. So even there, we say that since the advent of the Constitution, both cases should be looked at by the SCA and interpreted in terms of the Constitution. But I agree, Justice Majid, my main argument on this point is that since Basson, Sekwe is not good law anymore, and that this court will not follow Sekwe, and that this court will not require a complete acquittal or where the accused or the respondent is set free. So if I make that point on the Sekwe issue, and if I may, with respect, then proceed to our second tip, and that is to convince this court that we are dealing with errors in law and not errors in fact. Also, our argument is not an argument masquerading questions of fact as questions of law. Our main argument is that the court misapplied the principles regarding circumstantial evidence. Not only did the court ignore important circumstances, that's the one thing. Secondly, the court viewed the circumstantial evidence in isolation, which we've indicated goes back as far as de Villiers, good law on how a court should evaluate circumstantial evidence. Not in isolation, but as a whole mosaic. So the first point I wish to make, and I wish to argue. The court, although the court said that the court took into account all the evidence, although the court said I took into account the tampering by the police and what happened in the bedroom, that the court only paid lip service to that, because that's the last. It's one paragraph in a judgment. The court never went back to discuss the circumstantial evidence in what happened in the bedroom. The court was at pains to follow the evidence of the time since the accused moved to the bathroom. What happened afterwards, the court relied on, but the court erroneously failed to take into account what happened just before. And that's the most important aspect of this trial.
Mr. Root, just because the court doesn't continue to mention something does not mean that the court has ignored it.
Indeed.
I mean, she cannot.
Yeah, indeed. Justice Bachmann, I agree 100%. May I make two submissions? Firstly, in the matter trainer that we referred to, the court clearly said, although the magistrate in that instance made a finding that the doctor was a good witness, never referred to it again. And that was an error. Because there the court said, although you refer to something, if you don't use it again, that's just lip service. May I also refer to Singh? In the matter of Singh, It's not in my head, so may I just indicate the citation. It's S versus Singh, 75-1, at page 227. It's a Natal Provincial Division matter, where the court said at page 228 at G, the proper approach in a case such as this is for the court to apply its mind not only to the merits and demerits of the state and the defence witnesses, but also to the probabilities of the case. It's only after so applying its mind I'll get there. It's only when it applies the court will be justified in reaching a conclusion as to whether the guilt of an accused has been established beyond all reasonable doubt. The best indication, and this is important, Justice Partman, for my submission, the best indication that a court has applied its mind in the proper manner in the above-mentioned example is to be found in its reasons for judgment, including its reasons for the acceptance and rejection of respective witnesses. There's nothing further in this judgment indicating that the court either accepted or rejected it. The court ignored it. So, Justice Bartman, our respectful submission is that the court paid lip service to it by saying it's the same as the court saying, I've listened to everything, I've listened to all the evidence, this is my finding. With the utmost respect.
Where the finding is so irreconcilable with certain circumstantial evidence, then you can draw the inference, if you can call it that evidence was not in fact taken into account.
Yes, indeed. That's the point we're making. If it's just ignored what happened before the time, and it's irreconcilable with the rest, that the court did not take it into account. Justice Bartman, I don't have it in front of me, but if I remember correctly, the court said, I will get back to it later. It will become clear later. It never became clear. It never became clear. So if it never became clear, the court ignored it. Justice Party.
You were reading from the Singh decision.
I was indeed.
Yes.
And then I was handed a different document. May I have 1 minute just to see what I was handed? It is indeed, it is the Canadian decision that we made available to the court, R versus BG. May I refer in that particular matter to page 194 at D.
At D or B?
At D.
D.
It's from C to E, but it's right opposite D, Justice Party, where the record, including the reasons for judgment, discloses a lack of appreciation of relevant evidence and, more particularly, the complete disregard of such evidence, then it falls upon the reviewing tribunal to intercede. It is on point.
Mr. Now, would you mind referring to the paragraph? The printout that I have is differently numbered. Would you mind referring to the paragraph that you just read from the Canadian case? I think one of my colleagues has the same problem.
If yours is paragraphs.
I will do so. My junior will just hand it to me now. I also have a different document. He is the person that made that available, and I will refer to the paragraph, if you allow me, just for him to look for it. As a good. Getting to Mahmoud. Whilst I have R versus B with me, I think it's brilliant where R versus B explained the whole process, where the R versus B said a court will wear two hats. It will be the trier of law and the trier of fact. May I just extend that by saying, in fact, it's three hats. Before you evaluate the evidence, there's the trier of law, the principles, the legal principles in evaluating the evidence. Then you make factual findings, and then it's a trier of law again in applying substantial law. So, if that is so, we're saying that the court erred in a hat as the trier of law to understand how to apply circumstantial evidence. And that is a legal question. But if the court did not apply the principles regarding circumstantial evidence and ignoring evidence, that's a legal question. We say that it's so important that if she took into account the evidence of Van Staden and Van Rensburg, if she took into account about the condition of the room, if she took into account that if the scene, as depicted on photo 55, I'm sure everybody knows, I can refer the court to the record if need be. If she took that into account, it's the fan, the duvet, and the denim. It's impossible. I go so far, Justice Mbatha, as to say, the court ignored the evidence, the most important circumstantial evidence that will make the accused version not reasonably possibly true, impossible. If it did not happen as he described, how he woke up, how he walked, how he moved the fans, then it did not happen how she left the bed. But the court just ignored it, and that's the most important issue.
Mr. Nel, what I find more troubling is how she dealt with Mangena's evidence.
Indeed.
She finds that he's an excellent witness, and if one reads the record, it's quite impressive on the cold record without having seen the witness and so on. But then you don't understand how she gets to where she does with the fact that she basically accepts what the appellant, what the accused said, that if he'd wanted to kill, he would have shot higher. Now, that is completely contrary to Mangena's evidence and his reconstruction. Indeed. So, I mean, the two never meet anyway. The finding that he's an excellent witness and he was never challenged, correctly so, and the ultimate finding in basically accepting part of the version of the accused. The two never meet, and that to me is very troubling.
Indeed,
on the point that you're just making now.
Indeed, Justice Majid, that's a second point. In not only ignoring circumstantial evidence, by ignoring a witness like in Trainer, that she found to be a very good witness. What is even more, if I may use the word troubling, is the fact that his evidence about the deceased standing upright, facing the door, standing right up against the door, was just rejected as it's not important. The evidence of, then it brings me, Justice Majid, if the court would allow me, the issue of the finding by the trial court that the accused would have fired higher. I make two submissions. Firstly, the court rejected his evidence as that of a bad witness. The court said he's a bad witness, I reject his evidence. Then not only did the court accept portions of it about what he thought he was doing, but against his defense. His defense was, and one can trace the defense back.
Which one of the defenses? Indeed.
But may I, Justice Majid, just take the court through how I understood it. If one reads the 115, the plea explanation of the accused, it is clear, and I don't have it in front of me, but if I remember correctly, the firing of the shots was precipitated by a noise. That's what it said. Not he fired at a threat. The firing of the shots was precipitated by a noise. Link that to his evidence in chief. Before I knew it, I fired 4 shots. Now, may I...
But he says he fired at the noise.
Before I knew it.
But he says he fired at the noise.
But
so he knew he was firing at the noise.
Justice Leach, if I go back to my first argument, his evidence has now been rejected, but you accept his evidence as far as the noise is concerned. Even if you do, he did not voluntarily fire. He said over and over and over again that he never voluntarily fired. May I refer the court to de Oliveira, the matter of de Oliveira, and for the court, just excuse me, I've got hundreds of papers, I'll find it now. And I found it. Excuse me, Justice.
The accused said the very same thing. In de Oliveira, the accused said the same thing.
Indeed.
Without thinking, I fired. And the court there found that that is completely incompatible with a defense of putative private defense.
100%, that's the point I wanted to make, Justice Lees.
And I suppose you'll also refer to it later when you talk about the imminent, the genuine belief of imminent danger.
Yeah, even perceived. even perceived. Thank you, Justice Majid. May I quote from it where the court said, the defence of putative private defence implied rational but mistaken thought. And that, Justice Leach, that is the crux of the matter. You cannot...
Putative private defence is available to a person who thinks that he's under attack, and there must be some reason for him to think that he's under attack, and that he needs to take these steps to guard against this attack which is imminent upon him. He's misread the situation, and the person who's attacking him, in fact, wasn't attacking him.
I understand, Justice Leach, but what is it? He must still have rational thought. He must aim his attack on what he perceived to be the danger, and he's not doing that in this particular matter. And for me, that is the most important. If he said that, and it was his defence that he aimed it at the specific threat.
Once he says, I did not have the intention to shoot, he can't rely on that defence.
Indeed, Justice Mhlantla. But what goes further, Justice Mhlantla, is that the court then elected that defence that he cannot rely on as the main defence in this matter. And that was the issue. And that, Justice Mhlantla, is a clear error in law. The error in law goes so far as to not only allow a plethora of defences, but then pick one. And it's not an instance, Justice Mpati, where we argue that because the accused was a bad witness, therefore he's guilty. We never said that. We just said, Justice Mpati, that you cannot have multiple defences, especially, Justice Mhlantla, where it excludes each other, where you need conscience actions, and where your defence is that I don't know why. The shot just went.
Being, after finding him a very poor witness, to pick a defence for him.
Indeed, Justice Bartman, that's how we set it out in our heads of argument. But Justice Bartman, there's one added issue, that he was not only a bad witness, he had defences that exclude each other. And the one that he elected to use, the court rejected that one and gave him another one. And Justice Bartman, it goes further then. The court then accepted the respondent's evidence about exactly what he thought, what he did, and why he did it in making a finding, which cannot be in line of the finding that you made about his credibility. Justice Bartman, what we then say is, we say, the court should have rejected his evidence as impossible if the court took into account the circumstantial evidence. And the court should have rejected his evidence because he was a poor witness. Then all that remains is the objective fact. On the objective facts, the accused cannot escape a conviction of murder. And that is what our argument is. Justice Mpati,
other than the state of the room, of the bedroom, ignoring Mangena's evidence, what other circumstantial evidence is there?
The evaluation of the circumstantial evidence in isolation. May I refer to one aspect? There's the evidence of Van der Merwe having heard voices at a specific time, and there's the evidence of the gastric content. Now, Justice Mpati, if one views that in isolation like the court did, you could say, 1 o'clock in the morning, she wasn't sure where it comes from, I ignore it. The gastric content, the times, in terms of the Dr. Simon's evidence, corresponds closely. But saying, it's not clear, gastric evidence is, I cannot really accept, because there are other witnesses that would say that it's not so.
But what is the relevance of the gastric content to what happened that evening?
The fact that the deceased was awake, around about 1 o'clock that morning, 1:45. I don't have the time with me, I apologize, but if the court will bear with me, and that must have been the time when they ate. Because
That must be the time?
that she ate something
Oh, yes.
for the gastric content to still be available. That would then support the state's view that the accused version is totally impossible.
Is that also the time when somebody had some voices?
That's Van der Merwe, indeed. That it's so impossible because they were still awake at that time. Why would the court not link the two and see that the only inference is that there must have been, let me put it at the best, discussion whilst she was eating. The court went so far, Justice Barty, as to say that she could have gotten up in the middle of the night and had something to eat. That's speculation. The court of quo was willing to speculate on two things. Firstly, on when she ate. And the respondent in his evidence said it was impossible. And it was not only impossible because he would have known, is that the alarm was activated. If she walked down, the alarm would have been activated. The second issue, Justice Mhlantla, was the issue of the cell phone. Taking cell phone to the bathroom, where the court said, I think she could have used it for lightning. If you make that finding, Justice Leach, and that was the first question I got, if you make that finding that she used it as a source of light, then we go back to the finding of the version of the respondent. That would have been clearly visible. So by viewing everything in isolation, we say the court erred. And those are the three major points. And Justice Barty, we are making no submissions on the screams because the court made credibility findings there and the court made findings there, and we're cautious not to do that. What we're doing is we're making submissions on evidence that was not rejected.
Well, can I? Yeah, you're talking about screams. I seem to remember that there was some evidence that certain witnesses heard screams before the shots.
Yes. And the respondent's version is that he screamed before the shots.
He screamed before the shots.
He said he screamed. We have witnesses saying they heard a woman scream.
But what did the judge below say about those screams?
The judge...
did she say anything about the screams before the shots were fired?
She said nothing about the screams before. She made findings of screams during and after, and related it to the sounds of the bat and the gunshots. But Justice Barty, we're so cautious to not masquerade our argument as a rehashing of the facts that we did not even deal with that because, and we say it with the utmost respect, Judgment Party, we don't think it's necessary for purposes of finding on the questions of law to go there. And when we make submissions, Judgment Party, the next submission I have to make would be, if the court finds in our favour on the legal questions, what then?
Before you get there, can I
Yes.
just raise something with you, which Mr. Roux and his colleagues raised in their heads?
Yes, Judge.
Like them, I also get the impression when I read your heads that from time to time it seems as if you are arguing dolus directus and not eventualis. I mean, matters like the gastric content, the screen, the cell phone, it's almost as if you're suggesting that this is direct intent. I just want to clarify with you. We're not going there.
No, we're not going.
Yeah.
I'm not going. Just a minute.
Because they make the point in their heads,
Yeah.
and I think rightly so. One gets the impression that you're trying to straddle two chairs.
Yeah,
Direct intent or dolus eventualis.
Just if the aim was higher, if the aim was at the head level, if there wasn't a door, if it wasn't behind a door, I would have made different submissions. But the submissions we made is that there was foresight, that a person standing behind a door in a small cubicle, if you fire 4 shots into that, a person will die. And reconciliation in the fact that the accused went ahead and fired 4 shots, not only just 1. So, Justice Majid, we're not going back to dolus directus, we're going to dolus eventualis.
So really your case turns on and boils down to this. That in the circumstances that prevailed, you're not persisting with the initial suggestion that was outlined as being the state's case at the beginning, of maybe an argument which led to her fleeing and locking herself in the toilet and then being shot.
Because of the rejection of the witness's screams, I'm not going there, yes.
So all we've got to call upon to decide is whether there was any misdirection and whether the finding should have been there was a person in this tiny cubicle when he fired 4 shots into that cubicle, and that constituted murder.
Indeed.
Now, in that regard, do you ask that it's murder with direct intent, dolus directus, or dolus eventualis?
Dolus eventualis.
I beg your pardon?
Dolus eventualis.
Dolus eventualis.
Firing through a door at torso level into a small cubicle that I know, being not an expert, but being trained in the handling of firearms, the foresight must be that somebody would die and irreconciled.
He must have foreseen, and therefore he did foresee.
He did.
That's the inferences that is to be drawn.
Yes.
But then where does the circumstantial evidence come into play?
Justin Party.
I mean, the court below found that indeed there was somebody behind the door, and it was the deceased, and that the cubicle was small, and if the respondent fired through the door of that cubicle, there was no room for maneuver. What's the circumstantial evidence that hasn't been considered? Where does it help you?
May I make 2 submissions? My main submission is, if the court took into account all the circumstantial evidence, the court would have rejected his version outright. Outright. Not taking into account that he fired high, he fired low, he heard a noise. Because
so the court would then have decided the case on the basis that there is no
version,
acceptable evidence from the defense,
explaining
from the respondent.
The objective fact of a person behind a locked door shot 4 times.
Yes. Okay.
That's it. That's our main argument. We have a different argument that even if he knew she was behind the door, the deceased in this matter, it's still dolus eventualis. But I think it would suffice for the purpose of this argument to say that.
Even on the finding by the court below,
exactly,
that he didn't know that it was the deceased behind the door, that doesn't matter.
Indeed. Doesn't matter. We've got a different submission saying that he knew, but be it made, Justin Party, I agree 100% that it doesn't matter. And that was our argument in a court of quo. I am not, with the utmost...
It might matter only in regard to the question of motive,
Indeed,
which might be relevant to the question of sentence.
Indeed.
But are you happy that we are to approach this matter on the basis that you seek ultimately a finding that even if he was under the impression that the deceased, Reaver, was in bed or somewhere else, whoever was in, he had the necessary criminal intent to bring about the demise of whoever was in the cubicle?
And I agree, Justice Leach, and I think it's important for this court to make that finding, because it's an interpretation and application of the law that, and I say it with the utmost respect, Justin Bob, that we cannot allow to stand. And therefore we say, even on that basis.
And that must be so because of the number of shots.
Just Bob.
I say that must be so because of the number of shots.
Yes. Justice Mpati, may I take the court through our submissions on, if you found in our favour on the legal questions, what then? Justice Mpati, whenever I make submissions on something that seems so easy for me when I read the Acts, I get worried if I don't get any case law supporting my view. Because if I read the Act with the utmost respect, Justice Mpati, 3221, may I just... I just opened my Criminal Procedure Act. May I quote from the Act?
Yes.
In a case of an appeal against a conviction or of any question of law reserved, the Court of Appeal may. Of any question of law. It's not a question of law by the state, it's any question of the law. May I then read B and C? Give such judgment as ought to have been given at the trial, or impose such punishment as ought to have been imposed at the trial. May I just qualify here? We're not asking this court to substitute the finding and sentence. We're asking this court to substitute the finding but refer back for sentence, because I think it would just be fair that if we have a different conviction, that the accused be allowed the opportunity to lead different evidence.
Well, we have no choice in the matter anymore. Bogarts, State versus Bogarts in the Constitutional Court has decided that when it comes to sentence, even in a matter where a conviction is substituted with a more serious offence, the Court of Appeal can't sentence. It must go back to the Crown Court. So there's no choice in the matter. Bogarts is binding law. We have to remit the matter for sentence anyway.
And Napolisa as well is binding on us. Napolisa from the same court.
Yes.
On sentence.
Yes. Yeah, same court. That's our argument. I have to admit that I haven't had access to that, and I didn't think of Bogart's case, but thank you very much. But our argument and our submission is that it would just be fair to go back, because I'm sure that lots of other evidence will be led by the state and by the defence if we have a different conviction. Now, if it's so, and I read C, or make such other order as justice may require. Justice Mpati, I think it's clear. May I refer the court to the Pillay judgment. It's a judgment given by a judgment party where, let me give the citation, excuse me. We haven't quoted it in our heads. Yes, it's
for the benefit of my colleagues. I remember it very well.
I always get worried if I have to do that, because I'm sure that you know it better than I do, Judge. It's 2004-2, South African Criminal Reports 419, SCA. Now, what happened here is, and it's just to build my argument, excuse me, Judge Mpati, what happened here is the state argued that some of the people that were acquitted should now be convicted because of the appeal. And the court correctly said that only in respect of a judgment or order which is the subject of an appeal would the court be able to substitute the sentence or the conviction. So even in Pillay, the court keep the door open to say that we will substitute the sentence if there's an appeal. So, and I agree 100% with that. We have I don't know to call it an appeal, but we have a question of law that will dictate that this court substitute the finding, as was made provision for in Pillay, with one of murder.
Didn't this court do that in Porritt?
Indeed, in Porritt. The court did it in Porritt. In Porritt, they substituted, and that would have been...
in making that finding, this court is then called upon to make a factual decision which differs from that of the court below, because the question of intent is one of fact. Of criminal intent is one of fact. And do you say that we can draw that? We can draw the necessary inference from the surrounding circumstances that the courts should have drawn?
Yes, indeed. Indeed, that would be the only argument that we would do. And may I also quote another judgment that Justice Leach Mpati would know well. Attorney General, Eastern Cape versus D. It's 1997-1, South African Criminal Reports 473. It's in the Eastern Cape Division.
Give me the
Where-
reference again, please.
It's a 1997-1, criminal reports, 473. May I quote from page 475 at H. In any event, I do not think there is a reasonable prospect of success in regard to the constitutionality issue. An appeal is not a retrial or a trial de novo. It merely obliges the court to make a decision on a record of the evidence placed before the court of quo. As such, it's an extension or continuation of the list between the state on the one hand and the accused person on the other. That would allow this court to do that, which I just suggested to
So now
justice.
the difficulty that the state has, as I see it, is section 3224.
Yes,
It looks innocuous in the whole construction of the section. And if you read it with section 324, it becomes even more innocuous. And the second part of that difficulty for the state is Mahmoud, where the court seems to accept, without debating and discussing the matter, that if the court finds for the state in the case of an acquittal on appeal, the matter must be remitted in terms of 324.
yes.
So that case stands in your way, isn't it?
May I make submissions on that? The
Well,
first-
I think I have a different view of the matter, but I'd like to hear you first.
I'll do that. Justice Majid, 324 is a necessary but not sufficient condition.
I beg your pardon?
It's a necessary condition to have a retrial, a trial de novo. Because 324 is in the case of an acquittal. It's in the case of an acquittal for this court to order a trial de novo. That is what 324 would give this court. Of a total acquittal, if somebody is. And it also deals with the issue of double jeopardy.
Yeah.
Without having this particular provision in the court, every accused and every respondent would have said double jeopardy. But this entitles the court to order a trial de novo.
But that's even more so if you read section 324, it deals with what we know as procedural defects.
Indeed.
In other words, the accused wasn't really acquitted on the merits,
Yes.
but there was some defect in the proceedings. And in those instances, justice requires that there be a retrial.
Yes, and I agree 100%. No, not retrial. I say that this court will have the power to substitute. Because in terms of 324, it reads, whenever a conviction and sentence are set aside by the Court of Appeal on the ground. And we say that in light of our argument that the court should re-evaluate the evidence, there's an error made by the Court of Quo, and substitute that error with one of murder. In the Mahmoud matter, Justice Majid, the court indicated that neither the respondent nor the appellant argued for a retrial or had any stomach for a retrial or was keen to, I think the words used, Justice Majid, was keen for a retrial. May I say that I don't think either of us, and I talk on behalf of Mr. Roo, would be keen on a retrial. But may I say that if that is the only way, and I'm not saying it is, Justice Majid, if that's the only way of correcting an error made, that is the way that we should follow. But my main argument is that the court should substitute and correct a clear error by convicting just on the objective fact the accused on account of murder and refer the matter back for evidence. Those are my submissions, Justice Mpati.
Can I just clear the question of the first question of law reserved?
Yes.
The first question of law reserved. Was that really a question of law or was that a matter of fact?
My respectful submission, Justice Mpati, it's a question of law in the following argument. When we argued it, our argument is when the court has the three hats. The first hat is the trial of law, to conceive the principles of donative in charges, to correctly conceive and to correctly apply it. That is what that question is. It's not about making a factual finding.
No, but dolus eventualis is a form of intent, isn't
Indeed.
it? And you get to it by either through the mouth of the accused or by drawing inferences from the proven facts.
Yes.
So it's an issue, it's a matter of fact. It's an issue of fact rather than a question of law.
But my respectful submission, Justice Party, is it's different. In our argument is the following. And you correct, Justice Party, may I just quote Bierkes' matter? In Bierkes' matter, the court said
Which
that...
matter? Bierkes.
Bierkes. We've quoted it in our heads. The chances of an accused admitting or if it appearing from other evidence that he had indeed foreseen a remote consequence are very thin. A court therefore draws an inference concerning an accused state of mind from the facts which points to it being reasonably possible, objectively seen, that the consequences would eventuate. But that is just the point that you made. We're saying that, as was said in Mahmoud, if the court made factual findings, like the court did in paragraph 18 and 19 of our heads, we set out the factual findings. The application of the principles of dolus eventualis to those factual findings is an error in law if you wrongly apply the principles. You may then, in applying the principles of dolus eventualis, reach a fact as far as intention is concerned. But the mere application of the principles of dolus eventualis to the accepted fact, that is a legal question.
Well, what are those principles and how do you apply them?
You have to take into account all the evidence. You have to take into account the evidence of the fact that if the accused had a defense of putative private defense, if he complied with all the provisions of putative private defense, what the court, may I just in party indicate how we say the court erred. The court erred in the evaluation of the principles of dolus eventualis by not evaluating the evidence, taking into account three things. The principles of dolus eventualis, a possible defense of putative private defense, and error objector. The court just wanted to apply the principles of dolus eventualis in isolation without taking the other two into account. And that is the error in law. Justice Party, may I just say that, and I say it with the utmost respect, the court correctly defined dolus eventualis. One can get that from case books, from law books.
No, it did.
But it's the application of that which you find in the case law that's an error in law. And the error here is that the court never took into account the principles of error and objector. The court said on two occasions the accused could never have foreseen that he could shoot the deceased because she was in the bedroom. Not applying error and objector facts. Once the court tried, and I use the word trying to do it with the utmost respect, attempted to say, or any other person for that matter.
Well, that's exactly what it said. She said, how could the accused reasonably have foreseen the shots he fired would kill the deceased as he thought she was in the bedroom? So that's just a misapplication of what dolus eventualis was.
Yes, indeed. And
the issue was not whether it was her. The issue was related to the person that was in the cubicle.
Indeed.
Who ultimately turned out to be poor Riva.
Indeed. And in our discussions, we said she had to keep three balls in the air at the same time. Dolus eventualis, putative self-defense, and error and objector, which she didn't do. And Justice Leach, if that is true, if
she's confused putative self-defense with intention as well. It's relevant to intention, but it's not exactly the same thing.
Yeah, but it's relevant. But Justice Leach, if in the way that the court just said she misapplied the principles of dolus eventualis because of the question she asked, that, we say, Justice Party, is the legal error. Not the finding of having applied the principles, but the application of the principles, as Justice Leach has indicated. So that is my argument, Justice Party, on question one.
Yes, thank you.
And those are my submissions. As a conclusion. May I just Majid up? I promised that to get something as far as R versus B is concerned. It's paragraph 33. That I
Paragraph
33.
Thank you.
As a conclusion.
Where do you find paragraph? I'm sorry to interrupt you. Where do you find? Oh, yes. Yes, no, I do have them.
Yes, Mr.
May I please report now?
Can you just give me a moment? No, that watch is way ahead. It's only quarter to. What is your watch? Quarter to. No. Then it's only quarter to. It's only quarter to. Yeah, that watch is wrong. Yes, Mr. Ru.
Thank you, Justice McCarthy. The starting point on behalf of the respondent is that if you consider the questions reserved, that those questions do not constitute questions of law. And what fortunately happened, in addition to the cases referred to in our heads of argument, the state made available a copy of the Canadian law R versus B, and we will extensively refer to R versus B in order to endeavour to demonstrate to you that the questions posed could never be questions of law. We still maintain that the attack by the state on the trial court's finding is on the basis, and I quote verbatim from the heads, is that the trial court allegedly followed a fragmented approach to evaluate the circumstantial evidence. That's in paragraph 26 of his heads. And according to the state, that's still in paragraph 26, the fragmented approach would be in the trial court's, and I quote, willingness to exclude dealing with the evidence that would conflict with the finding the trial court intended to make. So if I read that correctly, the state refers then in paragraph 31 to the alleged exclusions. Where it first starts to submit that the court made the following mistakes in regard to the gunshots, and I will deal with everyone. Secondly, in regard to the messages. Thirdly, in regard to the cell phone. Fourthly, in regard to the gastric emptying. And lastly, to evaluate the gastric content with the evidence of Ms. van der Merwe around the argument. Now, first of all, we submit that the court did not ignore the evidence or did not exclude the evidence. We've shown you we've pointed you to or directed you to places in the record where she deals with it. She deals with every aspect. She explains, and she had, and maybe it's important to appreciate this, that when the court refers and saying that she took into account all the arguments as submitted also by the defence and the accused counsel, regard must be had to the fact that she had very detailed written argument before the time, consisting of 200 pages, about 70 pages, setting out timelines and dealing with every contention raised by the state. Like, for instance, it was raised that was they not screaming before the shots. The screaming there before the shots was the screaming before the cricket bat noises, not the real shots. The court was at pains to first of all assess the evidence, to say...
But on your client's own version there would have been screaming, not from them.
That is so. That is so on his own version, but it was not heard. No one gave evidence about that. But what the court did was to say that the first step was to determine whether there was first, what happened first, the first noises and the second noises. And it was quite clear that, and the state in fact presented evidence that the shots must have been first because of the cracks through the bullet holes caused by the cricket bat. So that was common cause in the trial, that it was first the shots and then the noises, it could be confusing, made by the cricket bat. That was not in dispute. And if that was so, and on the state's own evidence, on Professor Simon, on Dr. Stipp, with that fatal wounding, it was not possible for the deceased to have screamed after the shots. So the court very correctly approached the matter and say, when I deal with the screaming, and that was of course in the context, and I understand not to confuse it with the Dolus Eventualis case, in the context of Dolus Directus, it could not be, because the deceased could not scream. And then she found a ring in truth in the neighbour's evidence to say, but they heard a man, and they're right next door, and there's a ring of truth there. And by virtue of expert evidence, she found the witnesses on behalf of the state dealing with the screaming and calling that and referring that and interpreting that as a woman screaming as unreliable. And she was quite correct. The same goes if I take every other point, and ultimately it takes me back, and I understand that, but I have to first clean the slate. It takes me back to the respondent's version. But before we get there, in fairness, if you get to the messages, the court correctly deals with, because all the messages were before the court, hundreds of them, WhatsApp messages, loving, 3 or 4 fights between them. She describes that, she says, that is what I see in a relationship. But it doesn't take me anywhere, and she's quite correct. The third one, the cell phone, she says, well, I have to speculate. What is it that the state wants me to find in regard to the cell phone? Is it the state's case that, on this main case, that the respondent was chasing her to the bathroom and she says, wait, let me first take my cell phone before I run? Or what was it? And she says, I don't know, but I'm not going to speculate. One point, for instance, in approaching Blom's case, in looking at inferences, is it was dark. Possibly she took it with. I don't make a finding that she took it with. I'm simply saying to the state, there are many possibilities. And I'm not persuaded that there's one in favour of the state that would compel me to reject any other version as being contrary to it.
She had a cell phone in the toilet and also locked the toilet.
Yes, I would also have locked the toilet when I heard someone screaming that there's danger. It sounds to me very natural.
But according to the defense version, she was supposed to be sleeping. She was supposed to be in the bedroom.
Absolutely. That is if we look objectively back. He did not know, but of course that's the important part. The respondent did not know that the toilet was locked. That's an objective fact, found retrospectively. That can't be held against him. I was just talking about the version, see it from the state side, on the state's analysis. The same with the eating. There was ample evidence on that, where Professor Simon himself said, we must be careful, it's not exact. We had Professor Ludlow saying that we have fasted patients for 6 hours and found gastric content. So it's not exact. And the court was not then bringing out a finding and say, well, I found that she got up at night. It is the main finding by the court is, if you look at the evidence, it does not give me the security to draw one inference from that, excluding the other inferences. And she comes back in dealing with all the evidence. I will come back to that. The argument, Van der Merwe's evidence was not that she heard two persons argue. She heard a woman's voice in an opposite direction. Then you have, countering that, the security guard, Mr. Barber, who was in that time, between around about 2:20, I think the exact time was 2:20, 2:21, right in front of the respondent's house where they have to activate a guard piece of equipment to say, I was here, I was doing my rounds. And there was no problem. Everything was fine. So it is unfair to say that the court just ignored evidence. The court took everything into account. And what we say, even so then, if we take that evidence and we say, now, what does it mean in the context of the case? Let's assume that the state, for purposes of today's proceedings, is correct. What would the screams mean? Would it mean that it gives rise to dolus eventualis? That cannot be. The screams has no relevance to dolus eventualis. The screams only had relevance to the state's main case, to say she was running away from him screaming. Forget about that, it could not have been.
Yes, I understand the state doesn't persist in trying to persuade the court that that's what the finding should be.
That is so, Justice Leach, but those are still the factors that he raised in order to criticize the judgment and to say that the trial court followed a fragmented approach. Those are the very factors relied upon by the state to say, look at it. This is not a factual finding. It is and we say that it's masqueraded, but I'll come to that, to say I rely on that. That's my opening gambit. I, as the state, rely on that to say she did not take that into account. Therefore, she did not. It was a fragmented approach to the circumstantial evidence. We say, it's not so, because we can point out every place on the record. But we say, even if it were, it's irrelevant. We're really busy with irrelevant. Ultimately, we'll come back to the respondent's version. That's why we were of the view what could have been placed before the court was the respondent's version, and then to consider that. But the difficulty was that the state needed to find or to construct questions of law from factual findings.
Mr. Luke, can I ask you, like I said to Mr. Nel, the one thing I find troubling, and I notice that in your heads, you deal seriatim with the aspects they raise in their heads, paragraph by paragraph, but what you don't deal with is the matter that troubles me most, is Mangena's evidence. But I mean, if it was excluded, is that not a misdirection on the application of the law to ask the question that was asked in Mahmoud, referring to the judgment of Fetum J.A., is to ask this question: do the proven facts show that the crime has been committed, the crime of murder, through dolus eventualis?
Just Majid, can I go to Mangena's evidence? Very good witness. I said it, I submitted that for the trial court. I didn't cross-examine him on most of the essential things. He was an important witness. He was the witness that eliminated the state's case where it started off with saying that the respondent was chasing the deceased on his legs. And he said, it cannot be, he was on his stumps. It cannot be, I've did my test. Mangena's evidence would not contribute other than to explain the shots read with Professor Simon's evidence. It must be borne in mind, if we think away the Dolus director's case, how would the respondent have known what the position was of the person behind the closed door?
Well, I'll tell you why it's important. It's important because his reconstruction shows that the person on the other side of the door was quite close to the door in that small confined space, and that person was standing upright. Now, even on his stumps, the accused aimed towards bodily parts where fatal wounds could be inflicted. That's the importance of his evidence. And that brings us back to dolus eventualis, which I'm sure we'll deal with thoroughly later.
Yes.
But that's the importance of his evidence, is it not? Forget about dolus directus, we're not there.
But that part, with respect, Justice Majid, I will come to when you fire shots into a door, what it means.
Bearing in mind that the accused is familiar with firearms, he also uses ammunition to his knowledge, which does great damage to bodily tissue. Those are all factors we must consider.
Justice Majid, I hope to make it clear later on that ultimately we have to consider the version of the respondent in relation to what he thought. The firing of the shots, it must create a difficulty. And you would have seen in my heads of argument, with great respect, that I did not deal with that extensively to make submissions to say that when you fire 4 shots into a door, that you would not foresee certain consequences. I did not make that submissions.
Can I ask you something? There seems, as I pick up from what this record was, that there was a reconstruction available in court of what this toilet cubicle looked like.
Yeah.
We've got photographs. I hadn't been able to find in the record the dimensions given.
I thought they were there, but it's relatively small, but if I may explain...
Well, I don't think relatively is strong enough. If you look at the photographs, there's room behind there for a toilet bowl and a person and just about nothing else.
Well, what there was is about, if I show about 75, 3/4 of a meter wall where the toilet was, so there's room for someone standing behind the wall.
Well, the toilet's exposed. If
From
the
the
door's
side.
open, that little wall provided no cover.
No, that is not so with respect, Justice
Well, if you
Leach.
look at the photographs,
Yeah.
it was very, very restricted
Yeah, if
cover.
someone stood behind the wall, that person was covered. It was not in front of the door. If someone stood behind the wall,
But
it was
was
definitely
there enough room for a person to even get behind the wall?
behind the wall.
Yes.
Absolutely.
Well, if you look at the one photograph with the rods through that, and it's taken from above, there was no place to hide in there.
Now that would, from the side angle going to the
No.
the toilet, Justice
Taken from above.
Just
You
leave-
can see there's no place to hide. If you put 4 shots through that door, you must surely foresee that you're going
All
to
I
shoot
can
someone.
say is, in the submission, because it's not before you and I've seen the toilet, there is a wall, and if someone had been behind that wall, it would have been safe.
Well,
between
the
toilet.
court below says there was no room for maneuver.
That is so, and that's the finding. But
And wasn't that correct? Wasn't that a correct one?
it's correct in relation to the objective facts, Justice Leach. It's true if you look at the objective facts where the person was standing and you fire shots through the door, there's no place for maneuver. On the facts found by the court. On Mangena's evidence, that's correct.
There's
we
absolutely
know-
no room to move. So if you knew that somebody was behind that door, if you look at the photograph that is in volume, what's this? Volume 12, I think it is. At page 2450. You put a few shots through that opening, there's nowhere to hide. It'd be a miracle if you didn't shoot someone.
I saw the place and I know there's a little wall, but
I'm sure you did.
I accept, Justice Leach, where the person was ultimately standing. And I think it can be dealt with this, that if it was not excluded that you thought that the person was standing behind the wall, it follows. That creates that difficulty, but I'm in a position to deal with it.
You see, the provision is the accused knew what was behind that door.
He knew there was a person behind.
Yeah, and he also knew there was no room to maneuver. Then you put 4, not 1 shot through them.
For present purposes, I will accept that the person was not covered by the wall and that by firing shots into the door that at least the possible consequence or the probable consequence even would be that you would injure the person and probably or possibly kill the person. I accept that for purposes of this appeal. But I say, and that is coming, and if you would allow me, I will come back to that in relation to the respondent's version, to say if that would make a difference in relation to the legal points reserved, whether that would ultimately in law make a difference, and that will be the argument. I'm not trying to stay clear of the factual inferences caused by shooting into a door, but rather whether that had any role to play in the assessment of what's in the mind of the person.
You accept that if 4 shots were to place through that door, the almost inevitable outcome was that a person would have been injured.
It would be very difficult for me to make a statement to the contrary. Very difficult, and that's why I did not make it in my edge of argument. Very difficult. But we say that before we get there, and that's what I was trying to do before, deal with the state's real submissions and the attack on the trial court's approach. Because if it was not a fragmented approach, then, and if I may refer you at this point to the decision of R versus B.
Mr. Will, would this be a convenient time?
Indeed. Thank you, Justice Department.
Yes. The court will adjourn for 15 minutes. Yes, Mr. Roux.
Thank you, Justice Party. I was about to refer to the Canadian case R versus B, and there are 4 really important passages in the case dealing with the distinction between a question of law and a question of fact, and I make the submission that it's not really different to the cases that we refer to in our heads of argument. But what is significant is in R versus B, the Supreme Court of Appeal referred inter alia to the Sunbeam case, also Supreme Court of Appeal cases, and Lampart's case. And if I may go to paragraph 23 of the decision, where the Supreme Court of Appeal reversed the Court of Appeal's judgment on the basis that they could not have intervened as the points considered by them did not constitute points of law. They say the following in the middle of the paragraph in reversing this decision. They say, namely, that a guilty intention existed in the mind of the accused. In allowing the accused appeal to this court, the judge held that a person's intention is a question of fact, and that in criminal cases there will always be some evidence upon which to rest an acquittal. It goes on to the bottom, in the last part of the quote, where it says, in the case at bar, the onus was of course upon the Crown to prove that the appellant did the acts complained of with the guilty intention specified in the section. If the learned trial judge erred in finding that the onus had not been satisfied, his error was one of fact, certainly not one of law in a strict sense. It goes hand in hand with the decision that's in the head note.
I think that's trust, that if you have regard to the evidence and the inference, you asked to draw an inference from, because it's the only way you can look into a person's mind is from, you judge the subjective intention that that person had by his actions and from the surrounding circumstances. And if that inference is then drawn, it is that he did or did not entertain the intent to kill. That's a factual inference.
And that goes further. It's later in paragraph 29, but it's in a head note where it says, of the same decision, where it says, an acquittal based on an erroneous conclusion of reasonable doubt constitute a question of law, but then it's important where the trial judge has erred as to the legal effect of undisputed or found facts, rather than the inferences to be drawn from such facts. And that's what we submit in this court. Ultimately, when we consider the evidence of the respondent, it is true that to some extent there was a vacillation, but I think that we can explain that. And I'm sorry for doing this, and I won't go to every passage, because we've marked them.
Are you finished with R versus B? Are you finished with R versus B?
I've finished with R versus B.
Because I'm not. And if you go further and look at paragraph 31, or lower down in paragraph 29, we cannot regard the provision as excluding the right of the Appellate Division Council, the Appellate Divisional Court, where a conclusion of mixed law and facts such as the guilt or innocence of the accused depends, as it does here, upon the legal effect of certain findings of fact made by the judge or the jury, as the case may be, to inquire into the soundness of that conclusion, since we cannot regard it as anything else but a question of law, especially where, as here, it is a clear result of misdirection of himself in law by the learned trial judge. So if you don't appreciate the law, then it's a misdirection. And further on, in paragraph 31, a question of law may also arise, it seems to me, when the trial judge misdirects himself or herself with respect to the relevant evidence. Indeed, the Court of Appeal in this case reversed the acquittals after concluding that an error of law had arisen due to the trial judge's failure to properly direct himself to all the evidence bearing on the relevant issues. So, if you fail to direct yourself to all the evidence bearing on the relevant issues, then there has not been a proper legal application. Then that is a question of law. And that's confirmed further if you go on, paragraph 33, which is the passage I think that your learned colleague read, but it goes on in paragraph 34. There is a distinction between reassessment by an appeal court of evidence for the purpose of weighing its credibility to determine culpability on the one hand, and on the other, reviewing the record to ascertain if there's been an absence of appreciation of relevant evidence. The former requires addressing questions of fact and is placed outside the purview of the appeal tribunal. The latter inquiry is one of law, so that is reviewing the record to ascertain if there's been an absence of appreciation of relevant evidence. It indicates a lack. The latter is one of law because if the proceedings indicate a lack of appreciation of relevant evidence, it becomes a reviewable question of law as to whether this lack precluded the trial judge from effectively interpreting and applying the law. So if you don't take certain factors into account, which should have been taken into account, you therefore, and in dealing with a legal issue, then the trial judge who does so cannot effectively interpret and apply the law.
I think that must be a correct exposition of the law.
Well, doesn't that give you considerable difficulty?
No.
I don't believe on the factual basis, if you look at what the trial court did, and that's what I was at pains in the beginning to say, let's look at the analysis, and I'll come to the respondent's case. Let's look at the analysis of the trial court's approach to the state's evidence. The trial
look at
court
the approach to the question of dolus eventualis.
Yes.
That you'll find at page 3329. I now deal with dolus eventualis, or legal intent. The question is, 1, did the accused subjectively foresee that it could be the deceased behind the door? And 2, notwithstanding the foresight, did he then fire the shots, thereby reconciling himself to the possibility that it could be the deceased in the toilet?
Yes, but I will come to that.
Isn't that an incorrect application of the law?
But I submit that was one approach, but there's also a second approach. That's correct.
No. Is that not an incorrect application of the law relating to dolus eventualis?
I have just the wrong page reference. I was trying to find it to have the exact one.
Oh, sorry, it's 1707. If that's the blue number.
Yeah, the blue number.
1707.
No, but that point, and if I may come to it, but I'll answer it now, but that point...
Because that, to me, is the primary difficulty that I have.
I think if you read the judgment before that, what the court was doing was to first deal with the state's case.
It dealt with dolus directus,
yes,
and found no dolus directus. And then went on to deal with the question of dolus eventualis.
Yeah, what is important is that it was all connected. When she dealt with dolus directus, and in rejecting the state's case, she made certain factual findings that then spilled over into her approach to dolus eventualis.
Maybe so, but this is her analysis of what the issues were in regard to dolus eventualis. And were they correct?
I will submit they weren't, if I may explain it. If I may make the submission.
Because that doesn't seem to me to be dolus eventualis. Because there, and this is where the error in persona comes in, there, the whole definition of dolus eventualis is defined solely with reference to Reva, whether he knew she was in the toilet at the time he fired the shots. And is that not a misdirection of law?
I submit not.
Because she goes on to immediately find that this court does not support the state's convention that this could be dolus eventualis. On the contrary, the evidence shows from the onset that the accused believed that at the time he fired the shots into the toilet or the deceased was in the bedroom. But he can be convicted of murder on the basis of dolus eventualis even if he did think that she was in the bedroom, because his criminal intent is defined as the person, whoever that person might be, in the toilet cubicle. So was this not a misdirection of law?
I submit not, and the reason why I say this, because that's one part of her finding, and it must be read with the factual findings before it can't be isolated with respect, Justice Leach. And if I may explain.
Well, I need some explanation as to why what she says is the test that she has to deal with dolus eventualis can be correct. If it seems to me to be not.
If I may first summarize, and then I will go back in more detail. The trial court, in analyzing the evidence, first rejected the dolus directus approach. And in finding there, she made two crucial factual findings. The one factual finding was that he genuinely believed that he was in danger. That's the one factual finding. The second factual finding.
Well, I'm not sure if that is so, but if you can draw me.
I will refer to the passages of the findings.
But let's accept that.
If I may just give an overall approach.
Yes.
So the one factual finding that she made is that he genuinely believed that he was in danger and was acting in danger. The second factual finding was that he genuinely believed that the deceased was at the time of the firing of the shots in the bedroom.
Yes.
And that can't be ignored, those two factual findings.
No, I understand that.
Now, it was in the context of that, when she considered dolus eventualis, to say, because it can't be isolated from the state of mind of the respondent, and that's why she absolutely correctly referred to error in persona or error in objecto, but say that that's not what it's all about. Because if I may use an example, if I shoot someone thinking it's A that's going to attack me, and I really believed I'm under attack, error in objecto does not come into it. Whether the person was A or B or C, it does not matter. And that's what the trial court was at pains to say. She said, I look at error in objecto and I understand the principle of error in objecto. If I shoot someone and I have a mistaken identity, that in itself cannot be a defense.
Which makes my difficulty even more pronounced, that she did correctly set that out earlier, but when she comes here, and this is her finding, these 2 pages are the findings upon which the whole case turns, insofar as dolus eventualis, she never deals with anything effectively but dolus eventualis is excluded because he did not know that she was behind the door.
That's on the one point, but it cannot be isolated with respect, Justice Leach. If I may take you to her analysis.
You see, I accept the 2 premises that you say she'd already just found, but in the light of that finding, her analysis of dolus eventualis, it seems to me, is wrong.
I think that...
Because the issue was not then whether Reeva was behind the whether he knew Reeva was in the cubicle. The issue was he knew a person was in the cubicle.
But I respectfully submit that's not even the issue.
Of course it's the issue.
If you would allow me just to take it back to the 2 factual findings.
Yes.
And assuming that the factual finding is that he shot because of a perceived danger.
That is a different issue.
If that's the factual finding.
The issue of whether there was the so-called putative self-defense which has been bandied around is something else. We're talking about intent, not unlawfulness. Putative self-defense has to, well, self-defense has to do with unlawfulness. Putative self-defense has to do with culpability. But we're talking about intent as to what was foreseeable.
But that's exactly the point, that the submission I'm making, Justice Lees. I submit that you cannot, from that piece of the finding, cannot isolate the factual finding that he genuinely believed that he acted in danger.
No, but that, let's
Because-
not get sidetracked by that. When he fired the bullets, did he know there was somebody behind the door?
Well, if I may use a different example, Justice Lees, I walk to a place and I fire shots through a door.
Yeah.
I know there's a person, and of course I'm guilty. Of course I'm guilty. Unless I say I fired those shots because I believed I was right in firing the shot.
Yes, no, I understand that, but that goes to the question of culpability. What we're dealing here with is the assessment of whether he and culpability in appreciation of whether he acted lawfully. That is not what is dealt with here. What is dealt with here is whether he foresaw. And as I read the judgment, and you must point out to me where I'm wrong. He says it is not dolus eventualis because he did not foresee that it was Riva.
Just if I may explain it in this way and make the submission, and I come back to what I've submitted, just for present purposes, accepting that a factual finding was that he believed that he acted in defence. It follows that there's one substantial ingredient absent in his actions for liability, and that is that he believed that he acted lawfully. There was no intention to act unlawfully or the knowledge of unlawfulness. So that's missing. And that was the judge's approach. And it must be read with that. So it was defining by the trial court to say, that is my factual finding. Now, when I now look at dolus eventualis, I need to consider two further questions. Because what I do not need to consider, once I find that there was an absence to act unlawfully, it does not really matter who was behind the door, save for the following. And that's where the finding comes in. She says, or the court, I apologize, the court says, there is of course one instance, and it's not in so many words, but if you read the finding, there is of course one instance where you believe, genuinely believe, that you're firing shots at an intruder, but you foresee and reconcile the dolus eventualis that it might not be an intruder, it might be the deceased, and it's in that context that passage must be understood, where the trial court found and say, I've already found now absence of one of the elements of the dolus event. But now I must go further. That in itself is not good enough. I must now consider, even accepting that he lacked the necessary intent for murder, did he not perhaps foresee that it was Riva in the toilet, the deceased, and did he not reconcile himself? And in that context,
the question of once, if you're going to come with a defence of putative self-defence, and I think you're going to be hard-pressed to bring the facts of this case within that, but if you do come with that, then it's a question of culpability. And that question of culpability wouldn't matter whether it's dolus directus or dolus indirectus.
I agree.
So it wouldn't be necessary if as you said, there's already been some sort of finding that there's a lack of culpability to issue it. I mean, one just can read what the judgment says.
But I can't, with respect, I can't take that part of the judgment and isolate it from everything else. And what I'm trying to submit is, if you read it with a finding, what the trial court was really doing to say, well, I found now as a fact that there was a lack of intent to kill. But now I must consider, did he not perhaps think, because that's the intruder theory, and I give him points, I bring that finding out in his favor on the facts. I do that. But now I must consider, did he not in the back of his mind entertain the thought that it could have been, or that it was perhaps, the deceased. And that's what she's doing there. She's saying, I cannot find on dolus eventualis, in view of what she's found before, I cannot find that it was dolus eventualis in the sense that he had dolus eventualis vis-a-vis the deceased, because my factual finding is that when he fired the shots, thinking it was an intruder, he genuinely believed, he bona fide believed, that the deceased was in the bedroom. And that is absolute, in law, a correct finding on an analysis of a previous factual finding in relation to dolus eventualis.
But the court now moves on. The court is at that point busy dealing with dolus eventualis. And the learned judge said, the question is, and then those are the two questions that she asked.
But I fully agree with what the trial court was doing, Justice Barton. If I may explain again, she's now already found that he genuinely believed he fired the shots at the intruder. That is now the end of the dolus directors. Now she thinks, with that finding in mind, is that good enough to absolve him from dolus eventualis? And she says, well, let's see, we know he was in the toilet, and I will develop that, but let's see, could he not perhaps have thought, in firing at the intruder, that it was the deceased, and therefore his absence of knowledge of unlawfulness would not carry conviction right through. It would assist him, because if he thought within the time, the frames of dolus eventualis, if he thought that it might be the deceased in the bathroom, it would not assist him that he genuinely believed that he fired shots at an intruder, because that would only assist him in respect of dolus directors. Therefore, if I look at dolus eventualis, I now narrow the question. I've already made my factual finding. I now narrow the question in relation to the deceased, and I say, I cannot find dolus eventualis because my factual finding is that he genuinely believed that she was in the bedroom. It's in that context. And that makes sense to me.
Yeah, but that makes identity, part of the inquiry.
It does not, with respect, and if I may explain my submission. The identity she dealt with, and quite correctly, the court found it is so that if you have a mistaken identity, that it does not give you a defense. But now I find in this case, I make a factual finding that he believed it was an intruder. Whoever that intruder was, that identity won't play a role, because it's now dealing with the culpability. The only time, and this identity of error and objector would have no relation to a consideration of dolus eventualis in relation to the deceased. Because she says, I must just now consider whether he did not perhaps think, entertain, that it was not an intruder. So identity does not in that respect come in. We all know with respect. I cannot argue that if you make a mistake as to identity that you can hide behind it. But once you don't have the required culpability, the required intention, it does not matter. It does not matter in law. And that is her finding. So she was quite correct in saying...
What is your case insofar as this intruder is concerned?
Well...
The issue.
Well, if I may...
He hears a noise. This is a person... He's not confronted with a person. He knows the person is behind the door. And he hears a noise. Could he honestly and genuinely have believed that he was entitled to shoot that noise? To kill whoever was responsible for that noise? Because that has to be established before you can have your putative self-defense.
Well, I approach it differently, but I will respond to the question. My submission is different with respect, Justice Leach, and that is that the trial court analysed this evidence. Because this is now not leaving out part of the state's case? Because I've demonstrated that.
Well, the trial court analysed his evidence and found him to be a shocking witness.
Yes.
And an unreliable witness. But then she said that his version, the accused suspected that an intruder had entered his house through the bathroom window, and that he genuinely, although erroneously, believed that his life and that of the deceased was in danger. There's nothing as a whole on the evidence as a whole to suggest that this belief was not honestly entertained. Well, was there anything that showed, apart from a noise, that his life was in danger? Or that he honestly believed that his life was in danger? Well, I know we live in times where people break into your houses and things of violence, but is a person in a small area, he's armed with a firearm, he went to confront the noise, armed himself, went to confront the noise, and then indeed what happens, there's a noise, and then he shoots it.
If I may turn it around in answering the question, I'm sorry, I'm not debating. If I may turn it around, would the finding be he's lying, he was not scared, he did not believe there was someone, and why was he shooting 3 o'clock in the morning into a door? Who would be in your house 3 o'clock if I find that you genuinely believed that the deceased was in the bedroom? That would be the converse. That cannot be.
Yeah, but was his action in shooting into the door, would he have had an honest and genuine belief that he was entitled to act that way?
We submit, yes, and that was the trial court's finding. And it's not that you disregarded evidence there. The state's evidence factually played no role there, because I've dealt with that. It was premised on a very different basis. This was now a pure analysis by the court on factual content before her. And that's a factual question. And what will happen if we reconsider that question and say, trial court, you were wrong when you found that he genuinely believed that it was an intruder? You were wrong. Your factual finding was wrong, and we're going to make it a legal finding.
I'm not saying that that was wrong, but was there any, on anyone's version or on a finding, that his life, a genuine belief that his life was in danger?
But again, that's the court's factual finding, and what this court will then do is to interfere.
You see, I don't believe there has been a factual finding made. You show me where the factual finding has been made.
If I might just go to the places. If I must just go to the various places, if you would allow me, Justice Leach. I've marked them. If you just bear with me.
See, the difficulty with a factual finding is it's a factual. The closest I think one gets to it is that the statement that I put to you, that he said this was his version, and it hasn't been disproved by the state. That isn't a positive fact of finding that he genuinely entertained this belief, especially in the light of the fact that she has found him to be such a poor witness who's given conflicting versions as to why he shot.
If you would just bear with me, I'll find which you said was in line. If you just bear with me, I've got a note of all the places. Just find it. If you just bear with me, I've got a note. She starts with the process, or the trial court starts with the process 1704 at the bottom. Where it said, the court correctly said, the starting point, however, once was whether the accused had intention to kill of whom he mistook as it. Then she goes on, what is stated.
Well, she goes on to say the accused had the intention to shoot at the person in the toilet, but states that he never intended to kill that person. In other words, he raised the defence of putative private defence. Well, that doesn't follow.
If I may go to page 1706.
Or do you say it does follow?
What follows after that?
No, I'm
she
saying
develops
to you,
it. Not that in itself, no.
No, so there's a misdirection at the top of 1705.
No, that's not with respect to misdirection. She says, it's a statement that she says.
He never
she
intended
says he
to
states
kill. Yes.
That he never intended to kill.
In other words, he raised the defence of putative private self-defence.
He did.
No, he didn't. That doesn't flow.
Well, I can take you to many places.
Putative private defence is what is then set up
yes.
by Smallberger JA in the De Oliveira case, which immediately follows that, which is not the same.
No,
you can have intent to kill.
What is not the same? From time to time, he said, I fired and I don't know why and I didn't mean to kill. But other cases he said, I fired
at the noise.
At the move, I believed the person was coming out and that I was in extreme danger. That's what he says, repeatedly.
Yes, but why did he believe the person was coming out?
He heard the noise, and he says there was a problem with the door when you opened the door.
And the door didn't open.
But he wouldn't know that at that stage.
Well, he's standing there, door's in front of him. He didn't see the person.
That is now...
He didn't know whether this was a 12-year-old child or a person armed with a submachine gun.
No, but that is also thinking away with respect. There stands a man on stumps. He's vulnerable. He's extremely anxious. We see it now from eyes where we look back, and we cannot do that with respect. We must take it in its totality, where this man is standing there, and it starts before, where that anxiety started when he's going to the bathroom, believing, incorrectly so, that there's a problem.
That.
Why else did he shoot?
Because he perceived that there was a danger, that there was someone in his thing. But
if that is correct with respect, then he could not have wanted to act unlawfully, because he believed the fact that he was wrong is something else. That's culpability. That's negligence.
Did he believe that he was entitled to shoot in those circumstances?
His version is that he believed his life was in danger and he discharged the shots. So you have to read in it. He's not a lawyer.
That must be bona fide.
But it was found to be bona fide. And I was coming to the passage, and that's the factual finding. And if we reject that, of course, if it's rejected, that factual finding, and say, well, he was not bona fide, he just shot for some reason 3 o'clock in the morning, then I have no case. But then I don't know why he shot. Then he wanted to commit murder on someone in the toilet, believing that the deceased was in the bedroom. Why would he do that? It does not make sense. It does not accord with common sense or probability. But when you look at the whole picture, the court found at page 1706, she talks about his erroneous belief that his life was in danger. And they say then, as a fact, there is nothing in his evidence as a whole to suggest that this belief was not honestly entertained. She goes, that's a finding. After she dealt with that for 4 or 5 pages, where she rejected something and said, there is nothing in the evidence as a whole to suggest that this belief was not honestly entertained. Then she goes to 1709. Where she says, the 4th line, it follows that the accused's erroneous belief that his life was in danger excludes Douglas. That builds on that finding, and she goes on again to 1726 and 1727, where she says, from paragraph, I'm going too fast, I'm sorry. I'm sorry, Mr. Partner. It's 1726, where she talks about his version again from line 18. And the version of the accused was that he fired the shots at the toilet because he thought there was an intruder inside the toilet. The sequence of events, namely the shots, the screams, the shouts of help, the sounds of the cricket bat striking against the toilet, the calls made by various witnesses to security to report screams and or shots, are more in line with the version of the accused. That cannot be ignored. And again on 1727, 11, line 11. From the above, it cannot be said that the accused did not entertain a genuine belief there was an intruder in the toilet who posed a threat to him. That's 4 times.
Sorry, what's that last paragraph?
I apologize, Justice Leach. I was a bit quick, I realized. It's page 1727 from line 11.
Thank you.
So 4 times that you come out with the finding that he genuinely believed that he was in danger and that's why he fired. Now, that is the point that we raised right in the beginning. And the first question that must be considered by this court with great deference is whether that finding is factual or not. And it is a factual finding. That finding is not where she left out facts that the state is complaining about. That finding is solely premised on what she listens to, what she observes. And she comes to a finding that I believe him in saying that. And the corollary of that finding is this, and she says that I'm unable to find that he had the necessary intention to kill him. What she meant clearly by that when she dealt with the elements is that he had the necessary intent to kill unlawfully. That he believed that he was right. That's a factual finding. And then when one develops that factual finding, she then acquitted him. And I will come back then to the second point. And she says, but that's not good enough. The fact that you genuinely believe that does not absolve you from liability. And I find a guilty argument on culpable homicide. Because you were just so wrong. You were wrong. You were just so wrong. But I'm unable to find, in fact not unable, I'm unkind to the respondent. I found as a fact that was your genuine belief. That's the factual finding, and that's what we repeatedly said in the heads of argument when we come to this court. It's a factual finding that, and whether the court considers that to be wrong, and that's also in the Canadian law. If I may refer to the R versus B case as well, where it says, it's paragraph 22, just as in party, where he says, however wrong, the Court of Appeal or this court may think that he was in reaching this conclusion. I'm of the opinion, with all respect for those who hold a different view, that his error cannot be determined without passing judgment on the reasonableness of the verdict or the sufficiency of the evidence. And in my view, these are not matters over which the Court of Appeal has jurisdiction. And that's exactly our cases. So we submit, once it's determined, and it is, that that's a factual finding, right or wrong, then we must develop that factual finding and say, where does it take us in law? Can you reintroduce then intent? And that's where the judge was correct and say, but I'm not going to stop there. Let me now consider, did he not perhaps, and I'm going to not to repeat, did he not perhaps take him away from this intruder? Did he not perhaps think it was Riva? And then the court brought out that finding and say, no, I cannot find dolus eventualis in respect of that, because he genuinely believed, factual finding, that the deceased was in the bedroom. And it's in that context that the finding is absolutely correct.
But are the questions that she asked correct with regard to dolus eventualis?
Yes.
Did the accused subjectively foresee that it could be the deceased behind the toilet door? Is that what a judicial officer asks in these circumstances?
Yes,
is it not that, did the accused subjectively foresee that if I fire through this door, the person behind will be...
No, with respect,
That's
not in the context. If we have an academic debate, that's the question, because we have to consider error and objective. But she has already made a finding now about the intruder. You don't reconsider and say, well, I've already found that he's not guilty because he believed it's an intruder. I've already found that. Now I'm going to stick to an old definition, not the old definition, an open one, and say, well, did he think there was a person behind the door? That's irrelevant because she's dealt with that. The moment she found that he believed it was an intruder, and she believed that excluded dolus, that was the end of that exercise. So you don't reintroduce.
Then she didn't have to deal with dolus eventualis either.
No, she had to, because the question is then, her finding was in respect of an intruder, her factual finding. So she did not have to introduce the wrong person, mistaken belief anymore, because she's dealt with that. Whether it was mistaken or not, she found an exclusion ground on dolus in law. And she correctly refers to the elevator and says, that's, later on, I'm confused now. She correctly deals with it and say then, and bring out the finding. But then she says, that's not the end of the question. I've dealt now with error, mistaken identity in relation to your culpability. You really thought it was an intruder, and it doesn't matter. And that's why she correctly says, I hear you. I understand error in persona. I understand that it's not a defense, that you made a mistake. But this is not what the case is all about. Because if you look at all the case laws with respect, most of them have an error in persona, where the son or the daughter or the wife or the husband climbs through the window. You have a mistaken identity, but once it has no relation to culpability, once culpability is not present, it does not matter. She then moves on, or the trial court moves on and say, well, that's not the end of the matter. Let me consider now dolus eventualis, but not dolus eventualis as this open concept in textbooks. Dolus eventualis on what's remaining.
And what was remaining then?
What was remaining was that they did not perhaps entertain that it was the deceased in the bedroom.
Yes, but then why does she conclude, if that is so, at 1708, how could the accused reasonably have foreseen that the shots he fired would kill the deceased or whoever was behind the door? So she then brings in somebody else. Clearly he did not subjectively foresee this as a possibility that he would kill the person behind the door, let alone the deceased, as she thought she was in the bedroom. And the version of the accused was that had he intended to kill the person behind the door, he would have aimed higher chest level. This was not contradicted. Isn't there a conflation between dolus directus and dolus eventualis?
Let's accept that, Justice. Let's accept that, sir. And let's accept that finding for present purposes is wrong. And let's put it one side.
Are you prepared to accept that this finding was wrong? That this finding, how could the accused reasonably have foreseen the shots he fired would kill the deceased? Do you accept that that was clearly wrong?
That's the court's finding. That's as far as I can go. That's the court's finding, but I submit that it does not resolve the matter. Because if her finding was in the first place...
But I'm sorry, before we get there, do you accept that this was an incorrect finding?
I cannot make any concession there. I've said what I said about it.
You had to argue not to make concessions.
I had to argue not yet. Thank you for letting me off there, Justice Lee. But I would say it makes no difference. And I've referred you to a very instructive article by Phelps at paragraph 32. And if I may just go there.
Yes, well, I think the learned author got some things wrong there.
That may be, but if I may refer you to paragraph 32, where the following is said.
Just a minute.
Perhaps, I'm sorry if I'm a bit quick.
Is what?
The first paragraph starts, page 32, starts on the dolus eventualis, and the second one...
Is that the numbered 32 or the top 32?
The top 32.
Typed.
The printed page 32.
Okay.
And I found that to be instructive. She says, perhaps on the facts, it might have been less controversial findings in the circumstances to hold that it was foresight of death. But this was the court's factual finding, and the accused would have been acquitted either way. But then, the important one, even on a finding of dolus eventualis indeterminatus, he would still have a putative defence on the basis of a genuine mistaken belief that he was under attack and acting under lawful self-defence. He would thus lack knowledge of unlawfulness, which would not be impacted by the error in objecto. So we say, even if that's the finding, and even if that finding were to be wrong, let's look at the principal findings. Once the finding on the facts was that he genuinely believed that he fired the shots because he was in danger, it excludes dolus, the one leg, it excludes dolus. And that's the end of the intruder line.
Well, it doesn't exclude dolus, it excludes the culpability.
Yeah, that's why I tried to say the one leg. The one leg of it. The knowledge of unlawfulness. Then we move to the second part to say, perhaps, maybe he entertained that it was not the intruder outside my finding. And she says, but I make a factual finding that dolus eventualis cannot apply because he genuinely believed she was in the bedroom. So he did not think and did not reconcile himself. Whether he was wrong or right, that's the factual finding. He did not. I find that he genuinely believed at the time that she was in the bedroom. Those would be an answer to the main count. Those would be where the error in objector was consumed and the answer on a factual basis on the dolus eventualis. And then the logic step would then be to move on to say, well, I've given you the benefit of the doubt, and she dealt with it. I've given you the benefit of the doubt, but that's diversion. Then I have to move on to negligence. And that's exactly what the trial court did. And we say, if we then take the purpose of this appeal before this court, and we look at the questions, we have to do a number of things with respect on dolus eventualis. We have to draw a line through the court's factual finding that he genuinely believed, whether that's wrong or right. Whether that's wrong or right, we have to draw a line through that factual finding, because once we keep that factual finding, it cannot follow that he should have been convicted of murder. Once we keep the factual finding that he genuinely believed that the deceased was in the bedroom, we can draw a line through the dolus eventualis in the remaining aspect. And then it's instructive to look at the state's, the points reserved, if I may go there. It's page 25 of the heads of argument, where it says, whether the principles of dolus eventualis were correctly applied to the accepted facts and the conduct of the accused, including error in objecto. I've dealt with that. I've dealt with the factual findings, be it wrong, be it right. So that first question can have no legal effect for purposes of section 319. It cannot be. If you look at the second one, whether the court correctly conceived and applied the legal principles pertaining to circumstantial evidence and or pertaining to multiple defences. What the circumstantial evidence don't really come into it, because the state's circumstantial evidence were all focused on dolus directus. When we look at the accused, where the trial court correctly said, I look at his version, and from time to time, he's saying, well, I did not really intend to shoot, and it was just a reaction and so on, but I find, looking at it holistically, I find on the facts, I give him the benefit of the doubt that he genuinely believed that it was an intruder, and that he genuinely believed that he was in danger. That's my factual finding. So it's not the question that she mistreated multiple defences. She says, I must look at it, and ultimately it's not for you to come and tell me what you believe the defence is. I must look objectively at the facts. And the fact that you lied is a factor that I must take into account. But that's not the end of the case. And I must ask myself the questions. And she asked the question. She says, well, objectively, the window was open. And so on and so on. So she refers to a number of factual content to say, well, that corroborates you. So although I don't like you, I think you're a poor witness. Not didn't like your evidence. I think you're a poor witness. I understand the onus. And I give you the benefit of the doubt, and I bring out the factual finding in your favor. And that's my finding. So the second point of multiple defenses, she correctly analyzed it. She didn't leave out something. If you go to the third point, she says whether the court was correct in its construction and reliance on an alternative version of the accused, and his alternative version was reasonably possibly true. It's actually a rewording of the second point, and he says you should not have found that it was reasonably possibly true. But she did not make errors in law in doing so. She may or may not have, it's not relevant, committed factual errors to say, well, I'm wrong in believing you. I'm wrong that you, ultimately, when I look at your version, and it fits in with your screams, it fits in what you told the people immediately after, it fits in with you hitting the door, it fits in with your anxiety. I looked at Dermot's evidence, I looked at the two Oscars, it fits in. Though I'm not really happy with you, it fits in. And I found myself unable to reject your version. Now, that is factual. The Constitutional Court in Basson made it plain and clear. If that is a point to be considered, it's a factual point, you cannot do it. The court does not have that jurisdiction. If I may move on to the second point on 322, Justice Mapati.
Yes.
On 322...
Before we go on to 322, can I just ask you this? Tell me if you're going to address it now. How do you view Siako in the light of the judgment of the Constitutional Court in Basson?
If I may give this answer, you would not have seen in my opposition to the legal points that I raised Siako, and you would have not have seen in the heads of argument that I raised Siako. Our reading of Basson was that it's really the end of that approach. You have to give it a constitutional interpretation. And though I understand what the motivation was behind the Siako case, I'm unable to make submission to say that it's a guillotine point today. I cannot see myself doing that. However, I must say my understanding of Siako was born out of the case was born out of a practical one. To say, what do we do now if someone at a full trial and he gets convicted now, say culpable homicide and not murder, and he serves his sentence, and now for some reason you send it back, how are you going to avoid double jeopardy? And the same sentiments were raised by Judge Didcot in Zoko, where he says it's inconceivable. He didn't distinguish it because he was dealing with 310, but he used the words. He says it's inconceivable that was in mind. But I think, and with respect, I don't want to put it higher, that the practical effect of the Siako principle should rather be considered when you consider whether or not to refer a matter back for retrial. That would make better sense to me.
Then all the factors that led to the decision and its predecessors.
Absolutely.
That you could only have an appeal if it was a conviction, and then the state could only appeal if the point of law was to the advantage of the accused rather than the state. All those factors would come in.
It must be that. That's how we read it, Justice Leach. The more difficult part was the 322. It didn't really make that difference to us, but I believe there's one interpretation that if one considers 322, that paragraphs, subsections 1, 2, and 3 were intended to deal with the accused position, and sub 4 with the state's position. And it's quite clear, and this becomes clear when one considers subsection 2 and subsection 3, because subsection 2 and subsection 3 deal with the position of the accused. And then only do we find then, what is it then when the state reserves a point of law? And then when one has that in mind, and you go back to the cases.
But sub 1 also refers to a question of law, which
Yes,
has been reserved.
Absolutely, Justice Matlantla, but one has to give meaning to it. And it was not without any pain that I tried to give meaning to it. But if you look at sub 1 and you ask yourself, if subsection 1 was, if 1 was there, Why is there subsection 4? Because one says you can do what's in the interest of justice. An interest of justice may be to refer to retrial. It seems that if you read a proviso to sub 1, it says, provided that if you do it, then you may not do it in certain circumstances, then you must find irregularities, and not only irregularity, but one that would give rise to a failure of justice. It seems that it's all connected to the accused approach, the accused position, and also subsection 3, because there would have been no need, if it was not so, to put subsection 4 onto the law books. And that's what happened in the Rosenthal case, where the court found, if I may just, where the court found, with reference to the Old Criminal Procedure Act, where they inserted in the subsection 322 sub 4 was then 369 sub 3. And the court found that here the accused were acquitted, so the only provision available is 369.3. That's for the state. The only provision. The court says there the only provision for that is nowadays 322.4. And exactly the same approach was followed in Zoko just said about this. Zoko's not important here. In Mahmoud, to say that's the only thing that we can do. It's the only thing, and that was on an interpretation that why is there a 322.4 in that section?
But is the other interpretation not the one advanced by Mr. Nell also, that 322.4 must make provision where there are complete acquittals? And if you look at 324, as I said to him, those are procedural defects, irregularities and so on. So the accused wasn't really acquitted on the merits, but on some technicality. And there, the legislature had to make provision for the state to have him retried in another trial.
Now, with respect, though, if you look at 3221C, it tells you that the court can do what's in the interest of justice. The court can order a retrial. It's nothing stop. If that's in the interest of justice, the state does not need the assistance there. It says, make such order as justice may require.
No, but that's not the point I'm making. The point I'm making is this. 3224 deals with where you have complete acquittals, where the accused walks out from the dock outside the doors of the court, based on a technicality. For example, as is envisaged in 324, section 324. There the legislature saw fit to insert a section, subsection 4, to make a provision for the state to charge that accused again. And that's where 322.4 comes in. I mean, why is that not a reasonable interpretation, other than the one that you've advanced?
That is an interpretation. I cannot say it's not.
Why is it unreasonable?
It's a reasonable interpretation, but what we're submitting to you is also a reasonable interpretation that's supported by 2 decisions of this court.
Well, can I then ask you this? If you read 322(1)(b) and C together, now, you've made the point with considerable merit in your heads that there's grave difficulties in envisaging a retrial in this case because of what's gone before in this case. And I understand that. Bearing that in mind, and considering that the entire record is before us, if we find for the state, why can we not, in the interest of justice, that sub C, give such judgment that ought to have been given by the trial court? As I've said, we can't sentence. So in the interest of justice, why can this court not make such an order?
We submit that, and that's again on interpretation. The one is that disjunctively, it's all or. It's the one or the other. But those steps we submit are there in the case of a legal point by the accused or a conviction by the accused. Because even if you give a complete acquittal on a legal point in 3221, then if 3224 was just meant for a complete acquittal, why can't 3221 with respect not also give rise to complete acquittal.
Well,
If you can introduce the state's question of law there.
Sorry, I'm not quite with you there.
If I may repeat the submission.
Yes, I just need to understand this. Why do you say that 3221 then can't apply in where the state appeals on a point of law, where there's been a conviction?
Where there's a conviction,
Yes. Not a complete acquittal, but a conviction.
it applies, but it doesn't apply to the state.
Yes, but why?
It says in a case of a conviction, the state would not appeal in the case of a conviction. Why would the state appeal? It's clearly meant with respect to my interpretation to say there's the accused is an appeal against conviction. The state does not have that right to appeal against conviction.
No, but you must read it further. Or of any question of law reserved. And question of law reserved refers to Section 319. And Section 319, and we know the history of that section in previous acts. Section 319 specifically envisages the reservation of a question of law either at the instance of the accused or by the prosecutor. And so I also, like my brother, don't understand how you get to this argument that 3221, 2 and 3 apply only on your interpretation in the instance of the accused. I don't understand.
Well, if we look at, if I may start at the back with respect, Justice Majid, if you look at the back and you look at the proviso following sub 1, it says provided that, and it only deals with the accused there. And sub 3 only deals with the accused. It does not deal with the position of the state. That's why. Whilst when you get to 4,
Why
it
do you
deals.
say that? How does the proviso affect it? How does the proviso affect it?
The only submission we make in this regard, if you look at the proviso has no relevance to the state.
Why?
Precisely.
It deals with, it says when a point is decided in favour of an accused, and then it tells you what the court must do and may not do.
But
And the second one is where there's a conviction. That's only the accused.
I'm sorry I interrupted you, but this is exactly the point. What the proviso does, it makes provision for a certain set of circumstances that may arise where the court finds for the accused. It has no bearing on the prosecutor. It doesn't mention the prosecutor because it doesn't affect the prosecutor. That does not mean, it does not follow, therefore, that the prosecutors are included in 1, 2, and 3. I'm having difficulty following your argument. You see what I'm saying? This is in to make provision for a set of circumstances that may arise where the accused is successful in raising the point of law. It says the conviction and sentence shall not necessarily be set aside. And one can understand that. From a practical point of view, we know how criminal trials go.
Justice Majid, I understand it, but if I may go back to 3221 to the word question of law, and I understand where question of law comes from, but so does question of law in sub 4 come from, and that's from 319. But that question of law can also incorporate a complete acquittal. It does not say in a question of law other than in the case of a complete acquittal. And for that reason, we say, if you look at it, if you look at 1, 2, and 3, and it's not without any constraint, it's not that I stand with absolute clarity, I don't. But if I look at that, my interpretation of that is, and that's been the interpretation by courts before, and said that's the only thing you can do. Rosenthal say that's why 313693 is on the book now. That's why they brought it in, also to deal with the position of the state.
Well, I'll tell you what puzzles me the most on that argument. It's Section 324. Do you have any explanation for why Section 324 only deals with procedural, as a layperson would call it, technical difficulties? Yes. You see, that's what that puzzles me the most. And there one can understand again why, in the interest of justice, the legislature has decided you cannot let an accused go off scot-free on a technicality, and I'm speaking layperson's language now. And therefore, there should be a retrial. Conversely, if you've had a full trial and there's been some mistake of law, the state now reserves questions of law, and this court on appeal finds for the state. You've had all the evidence. And therefore, why can't this court forget about, I take your point that it's disjunctive. Why can't the court, in terms of 3221C, say, In the interest of justice, it's not in anybody's interest, let alone the accused, to have another retrial, given what's gone before. And therefore, this court now decides on the record before it what the judgment should have been. Sorry, I've said a mouthful.
I understood. Thank you, Justice Majid. I think that if one interprets Section 324, one would see that it's really designed for an error. And I believe that the legal point is designed, a consideration of a legal point for an error. So it's compatible.
Well, not only an error, a technical error, isn't it?
Yes, but it's a technical error. Well, it talks about the technical irregularity. Now, technical irregularity, it's a wide concept, whatever it means.
Let's say the main witness. I'll tell you what that means, in my view. I may be wrong. What that means is, let's say the only eyewitness to the offense was a child, and that child wasn't properly warned in terms of the Criminal Procedure Act before giving evidence. And the judge and assessors, as the case may be, accepts that evidence, and that's the only incriminating evidence. The court is satisfied that that child's evidence is sufficient as a single witness, or there's other corroboration. But that child wasn't properly warned or admonished in terms of the act. That's the sort of error that comes in here, isn't it? Here we're talking something different. We're talking, for example, and I'm not saying that's going to be the finding, but let's say, for example, we find that the principles of dolus eventualis has been incorrectly applied, and that's an error of law. That's on the merits, isn't it? It's not a technical error. It's an error on the merits. That's how I understand the section, because it does puzzle me why this section deals with the sort of things that the court didn't have the competence to convict, for example. It's not an offense over which that court had jurisdiction to convict, for example, treason.
Well,
you understand what I'm saying?
I fully understand, Justice Majid. I think with 3224, with respect what the legislature had in mind, and maybe not with this most soberest thinking that you can dream of, was to say, well, I am going to afford to the state, I'm going to make it possible for the court to order a retrial without possibly scrutinizing the individual content in 324, because 324 is foreign in the sense that it's very difficult to force it into some findings that may follow on a point of law.
Now, you would also know on the law, on interpretation of a statute. Here the legislature has stipulated A, B, C. When A, B, and C happens in a trial, the consequence shall be proceedings in respect of this may again be instituted. There's a numerous clauses. It doesn't say, or any other matter where the interests of justice require. It specifically mentions those three aspects. And I say again, those are technical defects in procedure.
Mr. Root, maybe I found a judgment, State versus E, 1979-3, which deals with the point. I'll read the head note. It says, where Court of Appeal is convinced that the trial court, because of a wrong finding of fact or of a mistake of law, convicted the appellant of a less serious offense than that which, in terms of the indictment, he should have been convicted of. The Court of Appeal has the power, in terms of Section 322 of Act 51 of 77, to alter the conviction accordingly. In such a case, the Court of Appeal has the power to set aside the sentence concerned and either refer the case to the trial court for that court to impose an appropriate sentence, or itself impose a sentence.
That's true, Justice Mtlantla, and I've seen another case as well where they did not motivate it, but where it happened. But then I also see cases where it tells you that the only step that you can follow is that it's difficult. It's a matter of interpretation. It's a matter of interpretation. If the interpretation is that 3221 is not only limited to a legal question of law by the state, then it must follow, of course. Then it must follow that the court can apply 322. I have a difficulty just to understand 3224 then, what the purpose of 3224 was. Because if a wide interpretation is given to 3221, why introduce 3224 in the Act? Because then you can read a legal question also as be one that would follow an acquittal, a complete acquittal.
Maybe the intention was to make quite sure that if there was a decision was exercised under 322.4, the accused then couldn't raise a plea of outrefois.
That may be, and I think a second.
But you see, we're not dealing with an acquittal, but a conviction, but possibly an incorrect conviction. And if you accept that the court would be bound, the appeal court would be bound on the factual findings that are made, but there was an error of law made, then there would be no purpose in starting de novo. And one shouldn't exercise your discretion then under 3224, but you just make the order that should have been made.
Yeah, I understand that, Justice Leach.
And that would might, in a position like this, operate in an accused's favour, where factual findings have been made that an accused person might be very happy that they were made and not made in favour of the state on certain issues. But then the court is bound by those factual issues, but merely takes the final decision that should have been made. Take, for instance, this case. There's been an inference drawn in so far as dolus. If there's been dolus eventualis, if the court finds that, for instance, that it shouldn't have been culpa, but it was a question of dolus, you don't want to have the whole thing referred back, to start de novo, to go through the whole trial again. It's far easier to say, these are the factual, this is the factual matrix. There was an error of law. So the only factual thing that we're going to interfere with was the drawing of the inference and draw the correct inference.
Justice Leach, I try to make it plain that we also, from our side, we have a difficulty with the interpretation. I could simply give you the two interpretations. I hear you. I understand that interpretation. There are two interpretations. What complicated it is, of course, by virtue of previous decisions of this court indicating to us that's the only thing that can happen.
No,
but it's open. It is indeed open. If I may just come back to the merits on one point.
Yeah. Sorry, can I just add, before you go to the merits, it's interesting that, I mean, my colleague has referred to State versus E, but in commentary at 31-39, when the authors deal, commentary on the Criminal Procedure Act, when they deal with the powers of the Supreme Court of Appeal, if the question of law is decided in favor of the state, they say, they refer to the retrial at Court State versus Rosenthal, as you've done, but they also say the following, and I quote, if the record contains all the relevant information, the SCA may also use its powers pursuant to Section 3221 and deliver the judgment and impose the sentence, while we leave that aside, that should have been delivered and imposed by the trial court if the latter court had correctly interpreted the legal position. But again, they quote no authority, so I'm just mentioning it.
Yeah, I saw that. If I may just refer to Pillar in this regard, where I thought, and again with great deference, Justice Mpati, where I thought that the powers really that the court derive were the powers provided for in then Section 22 of the High Court Act to interfere. If I may just go to that passage, it is, and I understand the facts there where there was an appeal and there were acquittals which were not really before the court, but there was in paragraph 114, it says the powers of a court of appeal are derived from Section 22 of the Supreme Court Act, which provides for that. And then Section 322, and it's quoted, is then referenced to, and it says the subsection clearly deals with the powers of the Court of Appeal may exercise in the instance of an appeal against a conviction or where a question of law has been reserved for its consideration. It does not give a Court of Appeal the power to alter acquittal order or to substitute it with a finding of guilty. I just bring that to the attention.
I know my brother presiding was in that case, but they may have been wrong.
I will never dare to say that, Justice Mitchell. I I just referred to that. If I may just come back to one point on the merits, and I don't want to reinvent the wheel, and leave the factual point behind. When one considers the case and the intention or the negligence, we submit that it cannot be considered by simply saying that you must look at his evidence where it was contradictory and for that reason reject it and find that he did not act in a perceived danger. Because that would so militate against the prevailing facts. It would so militate against all the evidence on record where we have this absolute anxiety that was not in issue, where a psychologist appointed by the court tried to explain the two Oscars, and the one when he's 1.5 meter, and his fears, and his over fears, and his over anxiety. And that was also confirmed by Professor Foster, is general anxiety disorder. And it's that person that you must take and see him hearing a noise, and with his fight response, not the flight response, because he cannot run without his legs on his stumps. With that flight response going there and making observations in that condition, 3 o'clock in the morning. If you think that away, the question is, why did he shoot? Did he just shoot because he decided this is a good time to fire shots into a door? It cannot be with respect. There was a trigger element for him, and that trigger element was a continuous one, where he was standing there in that state of mind, and when he heard that noise, for him it was, that's it, they're coming out. And he says this on a couple of occasions. If you draw a line through that, and say, that's nonsense, you're a liar, you're a poor witness. Why did he shoot? Did he just go to the bathroom to fire shots into a door because it's practice time? It cannot be.
But what also cannot be is that the court gave every person with an anxiety disorder a license to shoot.
Absolutely not, and we're not asking for that. We say, that's why we can't generalize. We say, let's look at this fact. Are those facts present? We're not saying you're excused from firing. That's why he's convicted. That's why he's convicted of culpable homicide, because he was not excused. But now to impute intention because he contradicted himself, where he was trying to explain his state of mind in very, very difficult situations, is also not fair. So we're not saying walk away. There was no appeal against the culpable homicide. There's no exclusion of liability, but to say that that person went there, and why did he then shoot? If it was not that he was in that anxious moment, overreacting, but in his mind.
One shot, yes.
But we're not talking about one shot where you have a trained person. You shoot, the evidence was in quick succession. Do, 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 do. That's what it was. You trained and you fired shots in quick succession. And you should have thought better. Yes, of course. You should not have fired 4 shots. You should not have fired shots at all. But that does not impact of what his mind was thinking. And that's what the case law, the way I understand the case law, is at pains to say, be careful not to say what he should have thought. Look at his state of mind. And all we say, when you look at his state of mind, you cannot isolate it from who the person is.
How do you say this case differs from State versus Dollavera? How does this case differ from State versus Dollavera? Where the man saw a number of persons in his yard, in an area which is prone to housebreaking, crime and so on, and he fired. And the court found there was no, and the objective facts, there was no imminent danger, and found him guilty on dolus eventualis.
But the court rejected his version. The court rejected his credibility. That's the difference. Here we have a very different case. We cannot just, with respect, take the one case and say, there's a man with 2 legs standing there, it's not 3 o'clock in the morning, he doesn't feel he must protect someone. We have to look at this package. The package presented was very different. And my understanding of the case law, however unreasonable you are, if that's really your frame of mind, that's your frame of mind, and the law is not designed to punish you for a wrong frame of mind.
Well, what the law requires is that you must investigate. whether he did in fact hold a genuine belief in the circumstances of the case.
But if not, if he did not hold a genuine belief, what would one say with respect? Why would he have fired? Are we going back to the state's version that he wanted to kill the deceased, which cannot be, which was tested and rejected? It cannot be. Something must have happened in that man's mind that caused him to fire, and he explains that. If you think that away, there's no answer. There's just a person going 3 o'clock in the morning to the bathroom and fire 4 shots on the door. Something must have happened, and he explains this, and the background facts explain it. The experts explain it. It's the package. And it's unfair then to take him and see him now through a prism of someone else standing there at 10 o'clock at night or whenever with 2 legs on. We have this anxious person, the overly anxious person. We see Professor Dermond's evidence where with all the para-athletes, he scored the highest on anxiety. That's the evidence. He's overly anxious. Incorrectly so. But that's who he is. And he stands there and he's scared and he sees the open window, and that's what the trial judge was saying. He could see this objective corroboration for him. It's not that the window that he heard was opening was now suddenly closed. It's an objective fact. He's scared. He's really scared. He believes the deceased is in the bedroom because it's spoken to her before. When he woke up, it's spoken to her. So it's not that he believed she was sleeping there. He knew she was awake, but he knew she was in the bedroom. That's the finding. Now he fires. If it's not for that reason, and one tries to sit back and think, why did this man then fire the shots? There is no reason other than to accept the state's case, which cannot be, because it's inconsistent with the probabilities. It doesn't make sense. Then there's no reason, and that's unfair, to then impute him with no reason, say you're guilty. The state of mind is there, and it's consistent. But I'm revisiting the merits.
Yes.
Thank you.
Thank you.
Reply, Mr. Mayor?
I had the submissions I wanted to make.
You don't have.
Can I ask you something on this last point, which Mr. Rowe has made very emphatically? If we either are not in a position to interfere with that finding, it being a factual finding, or we do, for some other reason, find that he did not have a genuine belief, what do you say is the reason he fired? He did not harbor a genuine belief that there was an intruder there. I'm postulating it on the basis of Mr. Rowe's argument. I'm not saying that's my view.
Justice Majid, there could be very many inferences drawn.
Well, let me ask you this. Let me ask you directly, because this is really what my question should have been in the first place. Is it necessary for us to find a reason?
No, it's not necessary to find. But because if the very pertinent question you asked, Justice Majid, is the comparison between the two cases. We have the
I must say, of course, and you would know it as well as anybody else, that one must treat each case, especially when it comes to intent and unlawfulness in these sets of circumstances. Each case must be decided on its own particular facts and circumstances.
Indeed, but there remains a principle, Justice Majid. The principle is, in that particular matter, the court rejected his evidence. Our argument remains that in this particular matter, the evidence should have been rejected, but it is not necessary to make the finding.
Well, it wasn't rejected.
It is not necessary to find why he shot. What we have to know is that he did shoot in circumstances where he had foresight and he reconciled. That is the question that this court should ask itself, and that would be the end of the matter.
It is the finding that he did have a genuine belief that he was being threatened. Is that not a factual finding which binds this court? And if it is, how does it affect your argument?
I've got two submissions. Firstly, I say it's a factual finding, but the factual finding was made in a wrong application of the law in terms of multiple defences, in terms of circumstantial evidence. If we cannot say that a factual finding wasn't made, it was made, but it was wrongly made. If it's wrongly made, the court can interfere. The second issue is, if the court finds that there was a belief. Then we still have to deal with all the aspects as far as putative self-defense that one should deal with. For instance, was there an alternative? Because the court wrongly applied the principle of putative self-defense, the court never asked itself the questions. Was there alternative? Was that the only way? Was there a genuine threat to his life? So those questions, because the court of quo asked the wrong questions, was never answered. And this court cannot answer them because there's no version. As the court believes.
Yes, thank you. Contrary to what I heard earlier in the day, that judgment would be delivered today, judgment is reserved. The court